This short video is directed to expert witnesses, but lawyers would be wise to pay attention to it as well. It consists of excerpts from my longer video series, The Art of Expert Witness Testimony. This one specifically relates to expert witness depositions. This presentation is the second expert deposition video in the Art of Expert Witness Testimony series. The first video is the 10 Commandments of Effective Deposition Testimony, and I suggest it as a prerequisite to this one. This program is addressed to the experienced expert witness. At the outset, let me remind you of the foundational premise of all strategies and tactics of the expert's role in litigation. The role of the expert witness in a litigation matter is to perform an unbiased, competent analysis in the expert's substantive field. Unlike the lawyer, the expert is not an advocate for the client or the client's desired opinion. The expert's ethical responsibility is to be unbiased and to tell the truth. However, once the expert has competently derived the opinion, the expert becomes an advocate for that opinion, and the expert has a professional responsibility to successfully advance that opinion in litigation. That's the basis for the strategies and tactics presented in this video, and the expert's ethical and professional responsibilities outweigh any strategy or tactic of the expert's role in litigation. Having said that, however, understand that a deposition is a losing proposition for an expert. The competent expert's job is to make sure he or she loses the least. The lawyer's job is to make the expert bare his soul. The expert doesn't want to do that voluntarily. An experienced expert should make the lawyer work for it. And many lawyers aren't good enough to get all of that information from the expert, the bearing of his or her soul, or at least not good enough to get it without showing the lawyer's hand. A sophisticated knowledge of the strategies and tactics of the deposing attorney is essential to the deponent's ability to minimize the harm suffered by the experts in deposition. In another video in this series, I cover the lawyer's strategies for taking an effective expert deposition. I strongly suggest you listen to that presentation to understand how to respond to a competent lawyer. But back to the expert's role. While the official purpose of a deposition is to obtain relevant facts, the practical purpose of an expert deposition is broader. Recognizing that all of litigation is an argument, the deposing lawyer's objective is to obtain any information on the record that can be used to advance the opposing side of the argument at issue. In other words, that lawyer is coming after you, subtly or assertively, challenging every aspect of your competence, your qualifications, your analysis, and your opinions. The deposition isn't a casual conversation where you are explaining what you did to the interested lawyer. In fact, virtually nothing that happens during the deposition is important in the moment it happens. Its only purpose is to create a record of the proceedings for future use. In contemplating your expert deposition, you should think about the major points of logic in your analysis and practice articulating your rationale for these logical points. This practice should also be extended to weaknesses in the analysis. The expert needs to be able to put his best foot forward on both strengths and weaknesses of the analysis that he or she has undertaken. Now, an expert's strategy toward a deposition will be different if the case is expected to settle versus going to trial. This you should discuss with your client's counsel beforehand. If settlement is expected based on discussions with the lawyer, the expert's strategy will be to be more open and expansive in explaining her analysis and opinions. In a settlement strategy, the expert's objective is to educate the opposition on the strengths of the analysis with less fear of exposing the expert's opinion to cross-examination at trial. If trial is anticipated, the expert strategy in the deposition should be more closed, with concern for educating the opposition to the subtleties of the analysis and providing fodder for cross-examination at trial. A third strategy of completely educating the other side may have to be employed if it is anticipated that the opposition is trying to disqualify the expert based on a Daubert challenge. In that case, the expert must make a complete record showing that the expert has considered and competently evaluated all relevant facts and applied a supportable, logical analysis to those facts to arrive at a defensible conclusion. The natural tendency of a knowledgeable person explaining something is to try to clearly and completely explain the subject to the listener. This is not the expert's job in a deposition, nor is it a wise tactic. The expert's role is to answer the question asked, only the present question, and answer it truthfully. The expert's job is not to educate the uninformed questioner about the subtleties of the analysis that has been undertaken, unless the questioner is smart enough to back the deponent into a corner by asking for precise details of the analysis. And quite candidly, many lawyers aren't adept enough to accomplish that task. As you can see, this has only been an excerpt from my longer video series, The Art of Expert Witness Testimony. You really need to look at that series to understand the expert's role in giving effective expert depositions.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.